offense. He was acquitted of possession of cocaine. I'll begin with discussion of the exclusion of scientific expert testimony of Dr. Fabian, which bore on Mr. Marcus Phillips' perceptual difficulties, that he was of dull intellect and not an inquisitive person. Dr. Fabian was, his testimony was put on pre-trial during a hearing concerning admissibility, and the court excluded his testimony. That harmed Mr. Phillips because what we had was not a case with overwhelming evidence of guilt, not substantial evidence, and also the testimony, and another point of error, of Special Agent Chad Lloyd from the DEA.
So what is your strongest authority that it was an abuse of discretion to deny that testimony?
Because it was a denial of Mr. Phillips' defense that it was a constitutional violation, Judge Smith, that he wasn't able to put on, and we cite some of the cases, and admittedly, most of them are from the Ninth Circuit, but there is a Fifth Circuit case that approves of this line of cases, that when a person doesn't testify, they're certainly capable of putting on a defense by putting on evidence of their perceptual difficulties that would help a jury determine mens rea, since we determine that from the facts and circumstances bearing on the issue. Very rarely is there direct evidence of mens rea. And so, but here in particular, where Dr. Fabian's testing of Mr. Phillips was using the psychological testing instruments like the WACE and the MMPI test to determine that he was of this low intellect and not an inquisitive person, would inform the jurors in discerning that he had perceptual difficulties and also to help them determine what Dr. Fabian's conclusions were based on these psychological tests, that they would need, you know, his expert testimony to determine that. And that would help them, that is the jurors, determine from this impaired perceptual ability to determine if this is probative to the existence or absence of his guilty knowledge, where he's merely present in this home that he doesn't rent, own, or pay the utilities for, where he has no belongings but the clothing on his back, where he's sleeping on a couch in a back room with no toiletries and some underwear his aunt brought to him in a bag that day at the home, where the car he was borrowing had been repossessed, and so some of his clothes and papers that were in the trunk of that car were in a basket in the home. So he doesn't have any connection to the drugs or the guns, where those are kept in separate parts of the home in closed cabinets. And the guns under heavy furniture that the law enforcement officers had to tip over to access, not at ready access.
So is there any dispute? I apologize. Can you hear me now?
I can, yes, Judge Ho.
Is there any dispute that your client was seen back and forth between the house and the car and the various cars a number of times over the two weeks?
Right, there's no dispute about that, Your Honor.
So then what's the theory then, that he walks a lot outside the house but not within the house?
He was a couch surfer, Your Honor. He would stay with...
But he's not. You just said that he left the couch a lot to go to these other cars.
No.
You literally, I get your point, but I mean,
get what you're talking
he's not
about,
exactly,
it was a little echoey.
sedentary.
There were cars that came up. It was his aunt who brought him, like I said, the underwear, and then there was someone who brought some juice in a bag, which was found in the home. He greeted someone at a car, but the police officer said they never saw an exchange of any drugs by him, drugs in his hand, any drug dealing beforehand. They just didn't see it.
I'm sorry. I want to make sure I heard you. Your theory of the case is he did go to a number of cars, but they were friends bringing him supplies?
The woman who owned the home and lived there, that was bringing him a change of clothing, of underwear. It was someone that was coming by and saying hello, someone dropping off someone for the occupants of the home, I think some money that they owed them.
How many, do we have any evidence in the record, pardon my ignorance, how many different cars with different license plates and different
I think it
drivers?
was like 3 or 4 cars, 0 reports about the surveillance, 0 photographs of these individuals. The officers did not identify them or stop them or keep information about them.
You're saying, although there were various, of all the cars that he was seen approaching over this 2-week period while the agents were surveilling, it was only really a total of 3 or 4 of the same cars over and over again?
That the testimony was not that precise, Your Honor, because the officers kept not a single report of any of that surveillance.
Okay.
So it was just sort of, we don't know, it was general testimony. We do know that the aunt was moving, that she had used a moving truck, that she had then also was moving additional items away from the home in vehicles. That was her testimony, Tryphosa Nichols. And so that might explain a lot of that car traffic too, because they were downsizing from the home to an apartment. And so she still had toiletries in the bathroom, cleaning supplies in the kitchen, food in the refrigerator. Her husband's clothing was still there. They were mid-move. And so it was a convenient place for Phillips to stay the night on the couch. He would also, there was testimony, he stayed at the homes of the mothers of his children, that he received mail there with the aunt's permission, and also at his grandmother's home, and wherever else he knew people that could receive mail on his behalf. So
what's the theory then? It was all his brothers, not his.
I'm sorry, I couldn't understand.
All the drug paraphernalia, the drugs themselves, the gun, the theory must be it wasn't him, it was his brother? Is that?
I think maybe the aunt's husband, because the aunt did not know about the guns or drugs in the home. They were very well hidden. In the opening statement for the government, they admitted that these drugs were in the cabinets, specifically the crack cocaine that they claimed was on a counter later in the case. They, at 9:06 in their argument, said that was located in a closed cabinet. In their
Counsel,
Exhibit 2A, they also stated it was in a cabinet. I'm sorry, Judge Barker.
Counsel, you said at page 906 the government conceded the cocaine was in the cabinets, but wasn't that just the government's opening argument, and didn't the testimony at trial actually indicate that the cocaine, or at least allow a jury to find that the crack cocaine was on the kitchen counter?
No, Your Honor. It was only, the testimony was that it was on the kitchen counter when we placed it there. That was the testimony of Officer Sendejo at record 987. We placed it there to take the photo. So,
No, I think, didn't he testify that when he entered after SWAT cleared the residence, he saw the crack on the kitchen counter?
he said that SWAT came in first and that they did not take photos of exactly where items were found because they get moved. When we're collecting and discovering evidence, it gets moved around. And so he could not testify where that was when he went in, but in his actual report, he claimed it was in the closed cabinet.
Right, but the government never conceded that all of the crack was in a cabinet. They just said in their opening statement they thought the evidence would show that, and the evidence actually came out somewhat differently in the testimony that the jury actually considered in forming its verdict, correct?
Well, I think, no, Judge Barker, I think they definitely said that there was, I think, 400 grams of powdered cocaine in one cabinet and 100 grams located in another cabinet. They didn't say, we expect the evidence was shown. And then when the testimony came out, it was, well, I don't know where it was. SWAT went in first, but my report says it was in the closed cabinet. And this stuff gets moved, and we placed it there to be photographed. And Defense Exhibit number 33 shows a glancing view of that counter as SWAT is coming in, or just as, the body cameras are coming in after SWAT, and you don't see that plate on the counter in that glancing photo. So it's...
So there was testimony then that the SWAT officers removed crack from the cabinets and put it on the counter, or are you just saying the jury could have inferred that?
I think I'm saying you could infer that because there was no testimony from any of the SWAT officers except...
isn't that a classic jury question? We're just doing sufficiency review. Isn't it just for the jury to decide whether that's a supportable inference or not?
Well, I think, Judge, if there was testimony that I know it was on the counter, then I'd say yes. But we're, we have to look at the defects in the government's evidence, and they clearly moved evidence substantially in this case. They dumped baskets over, they staged drugs on tables that weren't there before, and there is that testimony from Officer Sendejo saying, I placed that there to photograph it, talking specifically about that plate of crack cocaine, the cookie photo.
Could you, if I could move to another issue, could you explain how Dr. Fabian's testimony would have been relevant and non-cumulative? Because as I understand it, the defense's theory was that your client had no dominion and control of the house.
That's right.
The government's theory was that he did. And the district judge basically said, whichever theory the jury accepts, Dr. Fabian's not going to really add very much. If they conclude no control and dominion, Dr. Fabian's not going to add anything. The jury will have already found that your client didn't possess. If they find that your client did have dominion and control, Dr. Fabian's not going to add a lot. It'll be cumulative and irrelevant there too. Why is that an abuse of discretion?
It's important because when someone remains in a home, even if they're an overnight guest, like Mr. Phillips was, that if they become aware that there's narcotics and drugs, then guns there, and they remain, then they're, acceding to that. They're being involved in that, and the jury could have found him guilty that way. And it was very important for us, since he was not intelligent enough to take the chance to put him on the stand to testify, that he needed to, and he had some priors that weren't coming in, except that we did stipulate to them for purposes of the possession of the gun by a prohibited person, that we needed to put on testimony. This fella didn't catch on to the drugs and the guns being there. He just didn't look, he wasn't inquisitive, he's dull, he just kind of hangs out in that back room, listens to the music on his phone. And so it was part of his defense that he did not become aware that there were drugs and guns in there, just like his aunt was unaware. That way they were there, even though she was still moving items out of that home to the new apartment. And so then on Special Agent Chad Lloyd, a very unusual expert testimony. It was very far-ranging. As we said, it went beyond facts that were in this case to counter surveillance, use of weapons, and the active and protection of drugs. A kilo package was held up when there wasn't even a kilo quantity of drugs involved in this case. No package like that was involved. No evidence, no testimony that crack was cooked or distributed or that there were street-level sales. In fact, Mr. Phillips, when he hears the entry into the home with flashbangs, he lays down prone in that back bedroom and waits to be arrested. No counter surveillance, no use of weapons, no ready access, no methods of drug traffickers, no modus operandi of a drug trafficking organization such as he testified to, and all this sort of testimony. And the very odd thing about it was that he hadn't read any reports about the case. He wasn't proposed hypotheticals, and we were denied the jury instruction that the jury should not consider his testimony as substantive evidence of guilt. And so we think because of the lack of substantial evidence of guilt, and that this was a constructive possession case, this evidence of cooking and hands-on dealing with the drugs, of counter surveillance and employing these guns, of modus operandi of drug organizations, was not only confusing to the jury, but without that instruction could have been used by them to infer evidence of guilt, used substantively. The cases that were relied upon to support the use of such testimony are invariably conspiracy cases, and where there is one case of one individual in a home, it's someone who they have evidence that is engaging in actual hands-on drug activity and hands-on the guns. So it was very prejudicial in this case, and I see that my time's up.
Yes, your time has expired, but you saved time for rebuttal.
Thank
you,
you.
Ms. Orr. Mr. Gupta?
May it please the court, Neeraj Gupta for the United States. If you can't hear me, just tell me, raise your hand or stop me. I just want to try to follow up on some.
And just a message for all of the counsel present for any of these cases, to the extent you can keep your mouth pointed toward the front, toward the microphone, it's a lot easier. I know we have these side tables where people like to arrange their papers, and I understand that, but when you're speaking and looking at things on the side, it doesn't come through as well. So
Okay, I'll keep that in mind, and if I
Mr.
get too
Gupta,
close and get too loud, let me know that as well. I'm going to try to follow up on
Mr. Gupta, may I ask a question about the sufficiency, and this also relates to Dr. Fabian's testimony. Aren't there a number of cases that say that even for someone who owns a house and clearly has dominion and control, the mere evidence of the presence of a gun in a house is not sufficient to prove possession of that gun?
That's right. There has to be knowledge of the gun in the house.
What evidence of knowledge here would have allowed a reasonable jury to find that even if he did have dominion and control, that he knew of a gun in a closet in a bedroom he wasn't staying in, and a gun that was concealed behind a couch?
Okay, so the knowledge is circumstantial, and it comes from a couple different facts. One of them is that the surveillance testimony has him living in the house for 2 weeks prior to the search warrant. The aunt testified that when she vacated the house 2 weeks before, she didn't leave the guns there. There's drugs that are visible on the counter. That's one of the things I wanted to follow up with you on. That's
Right,
it.
but, I mean, isn't that just saying he had dominion? I mean, as I'm saying, even if you live in a house, you clearly have dominion over the house, and you've lived there for more than 2 weeks, but a number of cases say that's not enough to show that you possessed a gun that was found.
That wasn't the government's theory, that he was an overnight guest and is being held accountable for a hidden gun in the house. The government's theory is that he knew the guns were there, that he brought them into the house to protect the drugs that were in plain sight in the kitchen. So the jury could infer that the reason the guns are there is to protect the more than $50,000 of cocaine that's in the kitchen. So the evidence of what I wanted to follow up on that's related to that, is the question that you were asking before about drugs in plain sight. So the citations are 984, 1019, and 1098. 984, 1019, and 1098. And that's the agents explaining these exhibits, 28 and 29. And if you look at those exhibits, it shows the drugs on the kitchen counter. And 28 is, everything has been moved for the benefit of the photo. And 28A is the body cam footage before anything was moved. And that's the testimony that explains that. It was followed up on in cross. And if you look at exhibit number 2, you'll see a map of the house. And you'll see that the kitchen is in the middle of the house, and in order to get to the bathrooms or the bedrooms, you have to walk through the kitchen. So anybody who's in the house for more than a couple hours is going to see those drugs. And that's a fact that's integral to sufficiency of the evidence. It's important for this Fabian testimony, for why it wasn't prejudicial or relevant. And it's important for the sentencing, why it's foreseeable that it could be converted. So I wanted to emphasize that. Judge Ho was asking about the exchanges. That is in dispute. If you look at page 960 and 936, that's the testimony of the two agents. Sendejo at 960, he's the person who was there for 2 weeks. He said he was there for 2 weeks. He was there at least 8 different days, at least 12 different times, and he saw multiple exchanges that, as an experienced narcotics investigator, he'd been doing for 10 years, looked like hand-to-hands. Bishop, who was there the morning of the search warrant, this is 936, said that he watched Phillips do 3 hand-to-hands that morning in the 3 hours that he was outside the house.
Opposing counsel said that it was the same 3 or 4 cars, or at least I think that's what I heard, that it was just, therefore it was relatives bringing in supplies that he needed. Is there anything in the record that suggests that there were 3 or 4 cars coming back and forth, or is it 20?
No, they didn't keep records of license plates.
I'm sorry?
They did not keep records of license plates, and they didn't stop the cars afterward to find the drugs because they were more focused on not blowing the search warrant.
Does that mean then that the jury could infer either that there were the same 3 or 4 cars, or that it was 50 different cars, since the record's silent, I guess?
That's right. So I wanted to go from this issue of the drugs being in plain sight to the Fabian issue. The district court gave 2 reasons in the record for why the defendant's psychologist wasn't admitted at trial. His testimony was usable at sentencing, and that was the purpose of his expert testimony. But at trial, as you described, Judge Barker, it was irrelevant, and I won't go over that. That was at 7:57.
May I go back? I apologize, but just
Go ahead.
you talked about the 2 weeks of exchanges that were witnessed at various times by the agents. Do you have a sense of how many different trips back and forth between the house and the car were witnessed by the agents?
The word was,
With respect to this one defendant, sorry, not his brother.
I don't think there's any testimony about the brother doing exchanges. And it was Sendejo's testimony around page 955 to 960. And what he said was that he was there for 2 weeks. He'd been there at least 8 times in 2 weeks, at least 8 days, more than a dozen times, and that he had witnessed multiple exchanges. The word is multiple that he used. And he didn't specify any more
Ambiguous
than that.
word, so, but that's what we have. Multiple could mean any number of things, but in any event, that's what the record is. It's just multiple.
Multiple, and as an experienced narcotics investigator, that's what he testified to. So going back to Fabian, the other reason why his testimony wasn't admitted was in the written order, page 578, that this was confusing, that there wasn't a defense about mental state, and this would implicate 704B. Again, it was not prejudicial here, and maybe this goes to relevance as well, because the cocaine was in plain sight. That's just a fact that keeps infecting every single one of these issues. The cocaine was in plain sight, and the testimony is not in doubt on that by these agents.
Is it the government's position that any time a firearm is found in a house that is controlled by someone who's dealing drugs out of the house, large quantities of drugs, that is sufficient evidence for a jury to find beyond a reasonable doubt that the gun was possessed in furtherance of the drug distribution?
No.
What additional evidence was present here besides the fact, and let's stipulate that a reasonable jury could find beyond a reasonable doubt that the defendant was in dominion and control of the house and was dealing drugs out of the house. And let's stipulate the jury could find that he was aware of and had possession of the guns. What additional evidence shows that the possession was in furtherance of the drug crime? Just the coincidence of those 2 facts, or was there something more?
You're reflecting the argument that's in the appellant's brief that cites the Castillo case. The Castillo case is miscited in their brief. It's actually a 7th Circuit case, not a 5th Circuit case. It doesn't undermine the conviction here. It explicitly distinguishes the 7th Circuit's approach from the 5th Circuit's approach. The 5th Circuit's approach is these Nunez factors, these 8 factors from the Nunez-Sanchez list. Those are in the jury instructions, and those jury instructions were given here in this case. And the fact the 5 of the 8 factors are applicable here. The accessibility of the weapon, that it was right behind the sofa, that was the testimony.
Well, that was one of them.
Right.
The other one was in a closet.
One of them was, yes, that's right. 2 of them were in the closet in the other room.
Yeah.
The type of the weapons, 2 of them were, it says pistols, but if you look at the photographs, they've been outfitted to look longer, and they're described in the testimony like rifles. The unlawful possession is a 3rd factor under Nunez-Sanchez. The fact that 2 of the guns were loaded. One of them had a bullet in the chamber with the safety off, ready to fire. And the proximity of the weapon. One gun was in the living room where the drug transactions took place, or in the front of the house. The other gun was in the bedroom closet on the other side of the kitchen. And if you look at Exhibit 2, you'll see that that's very, very close to the kitchen where the drugs are kept. And even under the Castillo case from the 7th Circuit, they found that the shotgun right next to where the guns are stored was a tool or a weapon used to defend the stored drugs, and that they affirmed the 924C conviction.
I mean, all of those factors seem equally consistent with the defendant possessing these weapons, if he did, for purposes of general self-defense in a crime-ridden neighborhood.
I'm not sure. That wasn't what the jury
Wouldn't
found.
you? Which of those factors would not be true if the defendant possessed the weapon for self-defense in a crime-ridden neighborhood? Presumably, he would keep it nearby and loaded and in his house.
I'll have to think about that. That's an exculpatory argument that could have been made a closing argument. But the review here is sufficiency of the evidence, and the inferences should be made in favor of the jury's verdict.
Was the standard beyond a reasonable doubt in the government's burden on this element, on the furtherance of drug trafficking element? The government bears that burden under 924C.
I think what's important for the sufficiency of the evidence on the 924C count is the circumstantial inference of knowledge. That there was $50,000 or more worth of drugs in the kitchen, and that's why the guns were there. So that's an important fact that supported the government's theory.
Right, and it is the government's burden to prove the in furtherance of a drug trafficking crime element beyond a reasonable doubt, correct?
That's right. All right, well,
Would Dr. Fabian's testimony have potentially allowed the defendant to strengthen his jury argument on that element?
yes, it would have. I do think Fabian's testimony was more relevant to the guns than it was to the drugs. Appellant's argument in the brief focused on Fabian's relevance to the drugs, but you're right that the strongest argument for his relevance was for those two drugs in the bedroom closet. But
So
it was still confusing according to the judge's written order. It still possibly implicated Rule 704D. So the question is whether it's manifestly erroneous that the judge made that finding.
do you think that the relatively weaker circumstantial case for the guns in the closet could make if there was error, could make it more prejudicial for those guns as compared to the pistol and the drug dealing charge?
If I'm understanding your question, the question is it more relevant for the guns and therefore possibly more prejudicial that it was excluded?
Yeah.
Yes, I think that's what I conceded. The question on appeal is whether it's manifestly erroneous.
Sure.
And that's why I emphasize that in the written order, the district judge pointed out that this could be confusing for the jury. Even at Fabian's pretrial hearing, he testified that the only time that he ever testified at trial was in state trial cases when there was a diminished capacity defense.
And
that was the orientation of his testimony, and it was going to implicate mens rea.
But as to your sufficiency point, there was testimony that the prior occupant did not leave any of the guns there, correct?
The prior occupant?
Correct.
That was the aunt's testimony, that's right.
Right. And that went to any of the guns, correct? The testimony was that when she left, there were none of the guns were there.
That's right. I think it was at 1080. That was her testimony.
And the only other person seen coming and going with frequency was the brother.
That's right. And the testimony of Sendejo was that Phillips was, the defendant was the only person who was ever there alone, but the brother did come and go.
And the testimony was that the brother was never seen there without Phillips, without the defendant, Marcus Phillips.
That's right.
And the door was locked when the SWAT team showed up.
But that was the testimony of the two agents was that the door was locked. The testimony of the aunt was that her key had been lost. So the government said that he had a key, maybe he didn't. But that was the inference that we drew when we were writing the brief. But the reply brief makes a good point that maybe it was just locked from the inside. So I was going to go to the continuance because I wanted to give you a citation. The reply brief characterizes this continuance issue as a denial of a drug test. That's not correct.
Well, first of all, this defendant was granted 9 continuances, is that right?
That's right. That's right. And the timeline, so we lay out the 9 continuances. Maybe it was 8 continuances, I'm not sure, but maybe the 9th continuance was denied. We laid out the continuances in our brief, and the timeline that we'd like you to focus on for the final continuance was laid out by the court orally and in writing, page 570 and 811. The appellant's affidavit does it page 544, and the government's brief does it page 7. And what you'll see is that there was 3.5 months between April 3rd and July 22nd. April 3rd is when they made the motion for the drug test, and July 22nd is when the trial occurred. And during that 3.5 months, they couldn't get the drug test done. And the timeline shows that the reason they couldn't get the drug test done was because of defense counsel's lack of diligence. Government's brief lays out 2 of the big delays that total 2 months, and the judge lays out some of the smaller delays at the beginning and end of this 3.5-month period.
Well, all in all, it was almost a year before the request was made for the drug testing. Isn't that right?
It was about, I'd have to look at the calendar, but that might be right. And then just to close out that point, the analysis under Meservey is still, was there prejudice to the defendant from this denial of a motion to continue? And in the brief, we explain why there wasn't. Page 751, defense counsel concedes that they already had this test from the government, and they never followed up and did the test afterward for a Rule 33 motion or for sentencing, which took place 6 months later. So there wasn't anything to this drug test. As for Agent Lloyd, in the reply brief, appellant tries to distinguish the government's cases that establish that an experienced narcotics agent could testify as an expert about the methods of a drug trafficking organization by pointing out that in the cases cited by the government and the court, that narcotics agent had always been an investigator in the case. There wasn't anything that I found in Fifth Circuit law that established that as a rule. And one of the cases that is cited quite a bit is an exception to that rule. So I just wanted to lay that out as evidence that no such rule exists. That's Spear 30 F3D 605. 30 F3D 605. It's not cited in the briefs, but it's similar facts where it affirmed the admission of a DEA agent's testimony who was not involved in the case. They were admitted as an expert witness, and it's the same way. And as the government argued at trial, it actually protects the defendant not to have this person giving profile evidence where they describe the defendant's behavior and then map it to model drug dealer behavior. It actually protects the defendant for this expert not to know not to know the facts of the case and just testify in general about drug trafficking organizations. I think the Lloyd testimony is part of where this circumstantial evidence comes in about knowledge of the drugs. Lloyd was the one who testified what the value of these drugs are. Knowledge of the guns, I might have misspoke. Lloyd testified that there's $50,000 worth of drugs in that kitchen, and that if converted to crack, it would be worth 3 times that much. That's part of the evidence that was put before the jury for why they could infer that these guns aren't just the guns that people keep in their house for hunting or for personal protection, but that these are what they seem to be: assault rifle type pistols that are put there to protect and further the drug trafficking offense.
And the defendant's fingerprints were not found on any of the guns?
That's right.
And they were fingerprint tested?
That's right. The testimony was that they never seem to find fingerprint ever, but they do it anyway. They do the test anyway. As to the Well, I'll just wrap up there. I have 13 seconds left. Does anybody have any questions for me?
All right, thank you, Mr. Gupta.
Thank you.
Ms. Orr, you've saved time for rebuttal.
So with regard to the weapon by the door, let me emphasize, it was behind a massive couch, and the agents, to get access to the gun, had to tip the couch over. It was very high-backed. It was not readily accessible near any drugs. There was not any DNA on the weapons either, in addition to there being no fingerprints, and there was expert testimony that you had to use some force to cock and load and pull the trigger on some of these weapons, so DNA would surely have been left behind had they been used.
Now, you do agree that the jury, if the jury concluded that your client was dealing drugs out of the house, they could consider that conclusion in deciding the further question whether he possessed the guns.
I think that not with regard to use of the gun in relation to drug trafficking, because I believe, Your Honor, there has to be active use, and then there's the proximity problem. These weapons were not anywhere near the kitchen where the drugs were in the cabinets, and I know we differ about whether or not Defense Exhibit 33 shows that not on the counter when SWAT goes in and there's testimony, everyone's moving things around, and there's this big forced entry coming in and officers coming behind. Sindesso's testimony.
But the crime is not use, it also includes possession and furtherance, correct?
Yes, right.
And so if your client, if the jury could find that your client possessed the gun to prevent or protect himself from being robbed of $50,000 worth of drugs that he was dealing, that would be possession and furtherance, even if not, or debatably
you'd
use.
have to actively employ it, Your Honor, or there'd have to be ready accessibility under Fifth Circuit case law. But there's no evidence that he accessed it. In fact, there's evidence to the opposite. What he does when law enforcement comes is lay down prone in the back room and doesn't do anything to protect any drugs or show any knowledge of the location of the drugs or weapons. Let me indicate, too, that the aunt that testified she was still moving out, she had been there that day. Officers observed her going in with the bag, and it looks like the bag contained the underwear that were on the new underwear in a package that are on the back couch for Mr. Phillips. She said she didn't observe any drugs and weapons, and so that's further testimony that supports the point that that cookie was placed there after law enforcement came to gather and stage evidence. And if you look at all the photos, you can see a clean kitchen dining room table that then it has money and drugs staged on it, clean counters that Defense Exhibit 33, and then staged for photos, which is appropriate to photograph the evidence. I'm not suggesting it's not, but officers could not say that that cookie was on and visible on the counter. And in fact, in Exhibit 2, Government Exhibit 2A, is their sketch of the home, the map of the home, and on there they indicate and have written marijuana's in a backpack on the floor of the living room, and that there's crack and powder cocaine in cabinets as they've sketched it out in this not-to-scale Government Exhibit 2A. With regard to Spear and Agent Lloyd's testimony, the problem is the jury should not infer from his testimony that my client was possessing drugs or knew of the weapons, because we specifically asked for the instruction, his testimony should not be considered as substantive evidence of guilt. And in Spear, the point of all these cases and our distinction is Agent Lunt and many of the agents in the cited cases were not the case agents, but they became familiar with the facts. They were asked, if in Spear particular, if individuals have taken possession of 30 grams of cocaine, do you have an opinion as to whether that person's possessing it and whether they're trafficking narcotics or if it's for personal use? So that the experts given facts about the case to help the jury reach conclusions about that. Agent Lloyd didn't get facts of the case, and he also didn't express an opinion about the case, and that's what's so unusual about that. With regard to the drug testing. There was a miscommunication between my office and the lab. We understood the lab had tested and reached a conclusion about the drugs and was just waiting for the check to issue. When it got to them, they hadn't tested the drugs, and so we needed 10 days for that result. In addition, every continuance was unopposed by the government and necessary. This was a state investigation handed over to the feds with no surveillance reports or photos or information, and we were clawing back for all the information we could get. I subpoenaed the body cams. I searched for all the reports that I could find. Thank you. Yes, thank you very much, and I appreciate it.
We noticed that you're court appointed, and we appreciate your willingness to take the appointment, and we also thank you for your good service on behalf of your client.
Thank you so much, Judge Smith. Have a good day.